the KFDA opposes a bill because it would allow a funeral home to be built on cemetery property that's been dedicated for burial purposes only. This overturns a longstanding Kansas statutory and case law. The bill, what it does is adds a definition of sepulture, which historically and in Webster, the Merriam-Webster dictionary defines as burial, interment, and place, and the act of placing a body in a tomb. And these are all functions that are performed by cemeteries and not funeral homes. There's right now one statute in the Kansas Cemetery Corporation law that refers to the term that the proponents are trying to add, purposes of sepulture. And in that law, it states that every lot sold and conveyed shall be held for purpose of sepulture only. There's a later statute, 17-309. It doesn't use the term purposes or sepulture, but it says basically the same thing. It says the cemetery corporation can convey burial plots for burial purposes only. So as you can see, sepulture and burial are basically interchangeable in the same thing. This bill, what we oppose is it would add under the definition of purposes of sepulture, mortuary and embalming services. And this would accurately change the meaning of sepulture, but it would also change current case law and statutory law on the subject. Traditionally, services performed by mortuaries and embalming services are distinct and different and regulated under different entities. So there really is no connection in Kansas other than a funeral home takes a body to be buried at a cemetery property. And it was mentioned that the case Frobenius, Conley versus Frobenius, and that was a case in 1978 involving a Salina cemetery. And it was a class action lawsuit brought by owners of cemetery lots in that cemetery to enjoin the cemetery from building a funeral home on their property. And the Court of Appeals, Kansas Court of Appeals, held in their favor. And I'm just going to quote, they said, the construction and operation of a mortuary on the real estate here involved, which was dedicated for purpose of sepulture or any other commercial use not directed to the selling of cemetery lots with proper access thereto or for the maintenance or beautification of the area, constitutes use in a manner that was not contemplated in the original dedication. They went on to say that those purchasers of the lots had no reason to believe that part of the dedicated area would be used for purposes other than interment. Funeral homes has continued to follow this rule. I know some people who own funeral homes and cemeteries have refrained from building on the cemetery property because of this law. So you could argue that it is unfair competition to others to build a funeral home on cemetery property. Cemeteries are used not by one funeral home, they're used for many funeral homes in the community. And some states actually outlaw combos in their states. Okay, yeah. Really the most important thing, though, we think is that those who have been buried in the cemetery can't speak for themselves, and those who have purchased burial lots for the future, they chose these lots for the peaceful enjoyment of the land, and so their families can come visit. So I think you should really take their views into consideration and their thoughts into consideration. So, and then finally, I just attached to my testimony an editorial that appeared in the Kansas City Star that opposed last year's bill, and the final line of that is bury it to rest for all time. So thank you.
William Sneed, are you prepared to talk now? Thank you. William Sneed, Legislative Council, Newcomer Funeral Services.
Thank you, Madam Chair, members of the committee. I am Bill Sneed, representing the Newcomer family. I'm really here to introduce them to provide you the testimony. The Newcomer family have been in Kansas, and they are actually a Kansas-owned and operated entity here in the state for over 5 generations. And in order for you to get a sense of how they interpret all of this, at this time, I'd like to introduce John Newcomer so that he could provide testimony to you all.
Welcome to the committee, Mr. Newcomer.
Thank you. My name is John Newcomer. Thank you for having me. I'm a 5th generation funeral director. My family owns and operates funeral homes and cemeteries in Kansas, specifically here in Topeka. We also do business in Junction City and Olathe. What we do is such a sensitive thing. And what many of you have not had the privilege to do is to meet with families who are making arrangements for the burial of their loved one at the time of need, or funeral arrangements at the time of need. And when people are doing that, they make those choices with the expectation that their loved one's final resting place will remain a cemetery in perpetuity. We have a commitment to families who choose to bury their loved ones or inter their loved ones in our cemeteries on a perpetual basis. So I stand before you not necessarily as a funeral director or a cemetery owner. My family owns Mount Hope. It was mentioned earlier today. My family also owns Memorial Park at 6th and Gage here in Topeka. Funeral homes and cemeteries have lived within the bounds of the law as they're written in Kansas for many years, and they serve the public good in a good way. So I strongly urge you to think not on behalf of a corporation's special interests today, but on countless individuals who have been interred at cemeteries in Kansas and cared for by cemeterians in Kansas for generations, and the commitment that we have that those areas remain cemeteries for peaceful enjoyment for all of time. Thank you.
All right, thank you. We'll have some questions here pretty soon. So that was John. So we're going to go to Aaron Bailey, attorney for Sloan Law. Welcome to the committee.
Thank you. Good morning, Madam Chair, committee members. Thank you for hearing us this morning. I don't want to get into the weeds of the legalese on this a little bit, but I do want to make sure that it's understood of what this is trying to do. A dedication for property, in this instance, for a graveyard or for a cemetery, for purposes of sepulture. At some point, somebody maybe 150 years ago donated that for public use and put that restriction on that property. What this statute's trying to do is to say now in 2021, we're going to change or try to change what that what that dedication was back whenever it was made. That doesn't make much sense, and I think that also, as alluded to by John, kind of betrays the families that relied on that ground being a cemetery and not having to worry about in 10, 15, 20, 30 years there's going to be a commercial enterprise run 30, 40 feet from it. I also want to point out, and I did mention this in my letter briefly, but back in 2008, this body did pass statutes dealing with trying to sell off excess real estate that has been dedicated for cemetery purposes. KSA 171375 and 171376 basically lay out a procedure that if you're going to be able to try to sell excess real estate for a cemetery, you have to make sure that it balances the public interest. It talks about prohibiting that use for purposes of a mortuary or a crematorium. That's important. This change, or this proposed change in the law, is directly in conflict with those two statutes. And if you read those two statutes, it gave a very fair balance of the public interest versus the need for saying, okay, we've got 40 acres, we don't need it for the cemetery purposes. So there's a procedure. You notice up the lot owners. You have to file a petition in district court. The court has to balance those interests to make sure that it's that everybody's interests are heard and taken care of. It also talks about a buffer zone, making sure that there's a buffer zone between the cemetery space and then whatever use that property would be once it's sold. So I just want to also, I know we're brief on time, this is very nonsensical, and I want to just bring an example up. If you dedicate property for a park, okay, back in, like, let's say 1900, if you try to legislatively say, well, now the definition of a park is going to be apartments and condos, that makes zero sense. And it doesn't matter what we try to define something in 2021, it's what was the grantor or the dedication's intent when it was made. So I do think this is ill-conceived. I would strongly urge this body to look at 1375 and 76, to look at how that was done just 12 years ago to balance the interests of the public that have relied on that area being used for burial purposes. And I'll be happy to answer questions when appropriate.
All right, thank you.
Thank you.
I want to thank all the conferees for getting right to the point. That also leaves us a little bit of time for some questions. I do have a question, maybe comment question. I had the opportunity to talk to Pam Scott just a little bit about this, because in my area we do have mausoleums and funeral accessories and other things right next to cemeteries, but they were planned ahead of time, is my understanding. They zoned for that facility to be next to the cemetery and the resting place. And so it sounds to me like this is a situation where maybe they're too, confined, that they cannot find another lot. But if they had space available next to the cemetery, they could do exactly what is already being done, or what I see at least in my area. Who wants to answer that question?
Well, funeral home could be built on adjacent property to a cemetery that was zoned for that purpose, because that land hasn't been dedicated for the purposes of burial. So, and the people that had lots in the cemetery would not have any expectations that on what would have been built on that property that is not a part of the dedicated cemetery property. And some, you know, I think there have been some cemeteries in the past that in the original plans have, you know, put space aside for a mortuary, and that gave notice to the people that were that were purchasing the burial plots that would be there, and not a potential parking lot next to, you know, their burial space that they chose long before that.
Thank you, Madam Chair. I don't know if this is a question or more of a comment, but this right here, kind of to allude to the chairwoman's position, is every community is different. In Kansas especially, where I come from, versus Olathe in that aspect. Aren't most of these things taken care of with local zoning? Why are we dealing with this here? Why is this a state issue? This should be, in my opinion, a local issue.
That's a very good point. Local control is very important. And this seems to be a bill that is a solution looking for a problem. When we look at the purposes of sepulture, why use that word? As Pam was talking about earlier, that's only mentioned in these statutes very briefly. So this is really the state legislature getting involved with trying to approve a funeral home in Olathe. That doesn't make too much sense. And again, there is a procedure already spelled out in the cemetery code that would allow a cemetery with excess space to deal with that. So it does, in my view, does take away from some local control.
Okay, I'm hearing on the outside, just make sure you speak in the mics, and I know we're afraid of them in this room because they sometimes ring, but just Senator Dahl, did you have a follow-up?
Yeah, if I could. So here's the situation. Where I live is very rural, and we have a family come in and they want to put a cemetery home, whatever we're talking about here, in the middle of a cemetery in a small town of 5,000 people. If we pass this, or we don't pass this, would this prevent, this is the only way that this funeral home is going to come in and come into this town, if they can do this sort of thing? Will this disallow them from doing this sort of thing?
If the property is dedicated for a specific purpose, then that's what the property's been dedicated for. So to answer your question, yes, that would not be allowed. You wouldn't be able to build a commercial enterprise on property that's been dedicated for the burial purposes. That does not prevent somebody from building on adjacent property, as mentioned earlier. The other thing that's worth noting here is when these things were dedicated, we're talking about a century ago. They thought about this. So let's say I have 40 acres. If I dedicate 35 of that for those purposes, for cemetery purposes, I'm reserving the 5 to build my funeral home or whatever that I need to do. So it's not like this is just given no thought. This is particular property dedicated for a cemetery that I want to put a commercial structure on it. That's kind of what we're getting at.
Mr. Bailey, there seems to be uncertainty as to whether or not you identified yourself
sorry.
originally, and we just need it for the record, please.
You bet. Aaron Bailey, I'm an attorney for Newcomer Funeral Services Group. And I
Thank
did
you.
provide that written testimony that you should all have.
Okay, thank you. Senator Bowers. Okay, Mark?
Question. We originally tried to go local with the city of Olathe. Then we found out the roadblock was Conley versus Frobenius, so we had to come to the state legislature. One other thing, senators, there is no statute in the state of Kansas that prohibits you putting a funeral home on your cemetery. None. Never has been. And to Pam's comment, there's only 2 states in the union that prohibits combos, Wisconsin and Michigan. And that's another day, another story. So thank you. Frobenius. It was a 1978 lawsuit in Salina, Kansas.
So, Mark, I could ask you a question real quick. Thanks for coming in, by the way, too, from the city.
I met you last year.
Yes, I remember that, too. It's nice to see you. If this doesn't pass, do you have another option? Do you have a plan B?
We do not at this time, no. No, and I also should mention, senators, there are a number of combination funeral home cemeteries in the state of Kansas. In Kansas City, Kansas, in Wichita, and there may be others I'm not aware of. So this isn't something new. But no, we do not have a plan B at this point.
Would you say you're landlocked then? No space to go around nearby?
That's correct.
Landlocked.
That's correct. There would be no, as Pam mentioned, there is no adjacent, undedicated cemetery property that we could build on next to our cemetery. Yeah.
Thank you. And then Pam, I had a question for you also. Probably this isn't a new topic to your organization. Have you tried to deal with this internally to see if there's have you discussed this before internally with your board?
Well, last year and this year, our legislative committee and our board looked at this issue and pretty unanimously believed that it wasn't right to change long-term, case law. The Court of Appeals looked at this closely, held that it wasn't right to take dedicated property and use it for a purpose for which it wasn't intended. And, I even kind of question whether, apart from this, whether the rules concerning dedication of property would block it anyway, because there's a separate property issue if something's been dedicated for a certain purpose in real estate, state law, whether there would be problems with that also. But yeah, we have looked at that. I don't know what the solution is. It hasn't seemed to be an issue until, this bill. And, I have there's a funeral home in Wichita that's building a company that owns the cemetery that's building a funeral home, but they've done it on adjacent land, and they planned that because they knew of the fact that there was a Frobenius case out there, and they couldn't build it on the same property as the cemetery.
Senator Fascodo?
Thank you, Madam Chair. So Pam, just real quick, which funeral home is that in Wichita?
It is Broadway. I
Yeah,
can't remember the cemetery's name.
yes, starts with a C. I know that one. Thank you. But Madam Chair, my question is for the gentleman there. So would you, if this legislation passed, would you be able to do the embalming and just that whole part, or are you just talking about the service itself?
Patrick or Justin, what sort of Kansas license would we have for this location?
question.
Please you need to identify yourself.
Oh, my name is Patrick McGilly. I'm with McGilly Memorial Chapels. To answer your question, we would be a branch establishment. We would not perform any cremations, embalming at the location. It would strictly be services and conducting of arrangements and providing modern facilities that our customers currently want.
Senator Haley. Senator Erickson.
Thank you, Madam Chair. Senator Haley. My question is, I'm hearing terms like redistricting or dedicated or zoning. Can someone explain to me, like I know that property that's been dedicated or zoned for a certain purpose a long time ago is often rezoned or dedicated for a different purpose. Is there something unique to this type of property? I understand, the long-term of a resting place, but is there something unique in law or statute that is different in rededicating or zoning for these purposes? Thank you, Madam Chair.
To answer your question, when our cemetery, Oak Lawn Memorial Gardens, was developed 60 years ago, typically cemeteries back then, all the land they purchased, they dedicated. Because they never thought about putting a funeral home on there, they never thought about putting a mausoleum on there, they never thought about putting an event space on there. So this was long before Conley versus Frobenius in 1978, that the State Court of Appeals ruled that dedicated cemetery property could only be used for the right of sepulture, for the right of burials. So that's what happened.
Senator Haley, did you have a question?
Right on that line, Madam Chair, and I don't know if Mr. McGilly or anyone else would. So can you never sell or partition a part of the land? I'm thinking if there was a subdivision of the property that once it's for burial purposes, can there never be a subdivision or a sale of that part of that?
You can. Matter of fact, Mount Hope here in Topeka did that in 2008. They sold 40 acres off of their cemetery, which was dedicated cemetery property, and that's what their lawyer mentioned was the Kansas state statute.
So, Madam Chair, Mr. McGilly, after that sale, would it still be bound by the previous easements or commitments from?
No, because they actually got cemetery dedicated property undedicated, so they can do whatever they want with it.
So, Madam Chair, not to be devil's advocate, you have a 40 acre or however much of that property it is. Wouldn't you be able to rezone?
No, what we're not trying to undedicate our property. We're trying to change the definition of the right of sepulture to include a funeral establishment. We do not plan on undedicating the 3 acres that we're building on.
All right, thank you.
Last question on this item, Senator Straub. Please. I'll address the senator first, please. Thank you.
Thank you, Madam Chair. Quick question here. When these laws were written in 1868, were any cemeteries privately owned, or were all pretty much publicly owned?
They were right after statehood. So as far as whether they were owned privately, they were owned privately. So yeah, they were, and then there's cemetery corporations were essentially not-for-profit entities. So, and that's the other thing that we've got kind of going on here is that you have dedicated property for a cemetery, nonprofit, supposed to be for public use, to be able to use for a corporation for for-profit uses, which doesn't make much sense. And senators, to your point, there is a process to undedicate property. You can do that. And that's what I was talking about earlier, the statute at 1375 and 1376 in the cemetery code spell out how you can do that. And it's a very good roadmap because it does, you have to weigh the interests. It's not just you're going to run willy-nilly on property that's been dedicated for a certain purpose. You have to go through a process to do that. So I actually very, very much question what this law will actually do, because as a question that was brought up earlier, dedication of property is very separate than the definition contained in the cemetery code. So I would really urge everyone to take a look at that 1375, 1376 on that balancing of the act of when you do have that excess real estate.
Okay, thank you. I want to thank all the conferees. And we'll certainly have some time to ponder this. If we should decide to work this, we'll let you know, so you can either be here in person or via WebEx in the event that we have any questions. At this time, we're going to turn our attention to Senate Bill 52, creating the Cedric County Urban Area Nuisance Abatement Act. I believe when we left off last time, oh man, even mine's ringing.
Thank you, Madam Chair. I did ask for an update to that amendment and some additional information from the Unified Zoning Code. This is Marcy Francisco. I had indicated that I would try to address the other concern that the committee had raised regarding land that is zoned for specific agricultural uses, such as grain elevators that might be industrial. So the proposed amendment is still number 6, but it's dated February 4th, 2021. And this says that any area that is exempted from the Sedgwick County Code as part of any agricultural exemption provided by such code, and all other property used for agricultural purposes, including agriculture, agricultural processing, agricultural research, agricultural sales and service, and grain storage that is zoned to allow for such agricultural purposes.
Thank you, Madam Chair. So the concern of the committee, I think, has been defining agricultural purposes. And in the past, when it's been vague or not defined, leads to litigation, leads to court cases, because when we leave it to the county, as this amendment does, when we leave it to the county to define and restrict the definition of agricultural purposes in county zoning regulations, they get too restrictive. And it leads to court cases, and it leads to problems for our agricultural community. So given that the committee is interested in defining agricultural activities in statute and not leaving it open to interpretation, allowing a county to say what is and what is not agricultural would run contrary to the purpose of what we're trying to do today, which is define in statute what agricultural purposes mean. The definition in the amendment, again, leaves it wide open for the entity that is going to be conducting the abatement of the nuisance to define where they can exercise that authority. So it's kind of the, you know, was it the wolf watching the hen house or something? So to speak a little bit in agricultural terms. That raises concerns for me. So I have, Madam Chair, I have a substitute motion, or a substitute amendment, I guess, that I'd like to bring. Yes.
Who has, oh.
Madam Chair, should I explain the amendment? Sure. So it's kind of what we've been working on prior days, where we have specifically used the statutory definition that's already in place for agricultural activity. And you see it referenced there at KSA 2-3203. And that takes care of the problem of, well, what's the definition of agriculture? We've got a known definition right here in statute, and I think that accomplishes the purpose of the committee, that we're trying to define what agricultural means and ensure that the abatement of nuisances doesn't apply to agricultural activity. So with that, I would substitute my amendment.
We have a substitute motion, or are there questions on the substitute motion? Senator Dahl.
I hate to, I'm not trying to get into a debate with an attorney, but just say for purposes of this discussion that we declined the previous amendment and we just went with how this was, and we didn't have a substitute motion because, as you say, that's already defined there. So, I mean, why don't we just, couldn't we just turn down the amendment and then everything stays the same? Keep it simple. Does that make any sense to you? Probably not.
Go ahead, Senator Warren.
Thank you, Madam Chair. I'm a little unclear. The Section 5 of the bill we're looking at says for agricultural purposes, and part of the concern of the committee was, well, that's a little vague. What do we mean by that? So it's always more clear and certain and provides more, quite frankly, due process and notice to those who are going to be subject to this were it to become statute, if we can define it. And it's already been well established and defined in Kansas statute, as stated there in the amendment, which is amendment number 5, which is dated from Monday, February 1st. If that clears up the question presented by the senator.
Senator Francisco, did you wish to respond?
Yes, Madam Chair. I understood that there were some concerns that you were going to use to repair things, or you thought might come in use. This definition would not allow for that individual to have things unless they are used specifically for that agricultural purpose. So my question for Senator Warren would be, how would this affect a farmhouse on a property? Could that be cited for nuisance?
Thank you, Madam Chair. I think as long as, if we're looking at the amendment number 5, as long as there's agricultural activity involved, the property would not be subject to this abatement nuisance act.
Senator Haley.
Thank you, Madam Chair, and Senator Warren. My concern here, and this is probably a question more for the revisers, because I don't know how often the term, quote, agricultural activity appears in statute, but my concern would be if we carve out this exception for this specific bill where those terms, which are now defined in Senator Warren's amendment, might also apply and affect or disaffect other definitions in other parts of our statutes regarding what agricultural activity could be. This might be the nose, the proverbial nose under the, camel's nose under the tent, if you will, or what might shift traditionally what agricultural activity has meant with these exceptions specifically. It's probably a question for the reviser, because it's something I don't expect any of us to know the statutes.
Jason, do you have a short answer?
Yes, Madam Chair, under the amendment, this particular definition of agricultural activity is only for purposes of this section 5 to define what is not subject to the Nuisance Abatement Act. It has no effect, and there are no amendments related to the ag code, which is referenced in that amendment.
Oh, Madam Chair, Mr. Long, agricultural activity is not mentioned anywhere else in any other statute, any other Kansas statute, that specific term.
Yes, yes, it is. It's in 2-3203 that's referenced in the balloon. That's where
Finally,
that term is defined.
are there other exceptions in 2-3203 already, or in some EDSEC or some other statute where agricultural
Exceptions for
activity is?
agricultural activity, not that I know of. I think that term is only used in the act in which it's defined currently. There, that's 2-3201 and following. For the purposes of that act, that definition applies down there.
Thank you. Thank you, Madam.
Senator Bowers.
Madam Chair, I would like to second this motion.
We have a substitute motion and a second. Is there any other discussion? Seeing none, all in favor, Senator Francisco.
This amendment does not just reference KSA 2-3203. It also adds personal property, real and personal property, machinery, equipment, stored grain, and agriculture input products owned or maintained by commercial grain elevators and agribusiness activities. But is that it would be more appropriate to identify a property that then you know anything going on that property can't be declared a nuisance rather than activity. So I will vote against the amendment.
Generally, processing occurs within the cities, and they have their own set of rules and guidelines. And
Processing is particularly spelled out in the Cedric County Code as allowed in 2 of their districts in the unincorporated area.
Senator Straub.
Thank you, Madam Chair. While I would support the amendment, I still have a question, and I'm not sure if Senator Warren can answer that, but I assume that Cedric County has a zoning and planning commission. I think, if I'm correct, there's probably half of the counties in Kansas have a zoning commission.
They're the number 2, so.
And in the Cedric County Zoning and Planning Commission, what are the different classifications they could zone a property as, like commercial, residential, light industrial? What are all of their different classifications?
Without pulling it up on the website, they have all the things that you had mentioned. They have light property, machinery. They have a whole host, and it's a Wichita County Joint Metropolitan Planning Commission.
Thank you. That answers my question.
Any other questions? Seeing none, all those in favor of the amendment say aye. Aye. Opposed, no? No. Would you like to have your vote recorded? Senator Francisco wishes to be recorded. Senator Haley? Anyone else voted no? Are there any other amendments for Senate Bill 52?
Yes, Madam Chair, one amendment. It's a short one. It provides, again, I think it addresses appropriately a lot of the concerns of the committee, and it puts a 3-year sunset into the bill, so we can come back and say, has this been working? Has this been abused? Has it been effective? Do we need to change it? So if the committee assistant could pass that out. And it also does clarify, just to clean up the bill a little bit, you'll see that the bill right now, for instance, on line 6 of page 1, cited as the Cedric County Urban Area Nuisance Act. It inserts the word abatement, abating the nuisance. Yes, Nuisance Abatement Act. So it's not just about nuisances, but it's abating the nuisance. On page 3, we're adding a section that the act expires on July 1st, 2024. And with that, I move my amendment.
What is your, okay, I have a motion and a second by Senator Bowers. Discussion. Senator Bowers, did you have a question?
No, just seconding the motion.
So I have a question. What is the purpose? I understand the sunset, and I will say that I am fine with the sunset, so that we could take a look at this in 3 years and make sure it was properly used. But the fact that you put abatement in there, could you help me out a little bit more?
Sure, thank you, Madam Chair. The purpose of the act is to abate or get rid of the nuisance, for the county to get rid of the nuisance. And so it's just defining what we're doing with the act, is we're abating the nuisance. We're allowing the county to clean up the dilapidated, burned down house and things like that. So it's just a point of clarification about what the act is doing.
Thank you. Any other questions for Senator Warren? Senator Haley?
Appreciate the amendment and support it. I guess my quick question is, what if something's in the middle, at the sunset, at the point, what if they're in the middle of this process? They would be allowed to continue, I'll assume, Madam Chair, because they start before the deadline and it hasn't been resolved?
Generally, a sunset, they would already be in the process, and a sunset would have a to-be-determined date, which would probably be July 1, or whatever the legislature decides.
I support the amendment.
And so I'm sure that anything that's already existing and in process will continue. Senator Francisco.
Thank you, Madam Chair. I'm just questioning why it expires on July 1 rather than, I mean, is the intent that the legislature would look at it prior to this expiration?
We would need to do that.
Yes, Madam Chair and Senator, that would be the intent. And it would be this legislative 4 year, so it would be this committee, in essence, who could, oh, I remember we did that, and we can look at, has it been working, has it been abused? Thank you.
Any other questions on the amendment? Seeing none, all those in favor say aye. Aye. Opposed, no. Motion carries. Are there any other amendments for Senate Bill 52? Any other amendments? Senator Francisco.
I don't have an amendment, but where did we leave the question of owner or agent? I thought Senator Warren was going to help us with that.
Thank you, Madam Chair. I think we took care of that on Tuesday, that we cleaned it up so that it would have to be on the owner, not the agent, except as defined in how you get personal service on an agent of an owner. That we cleaned up, I think,
We proved that. Any other amendments? Any other questions? Senator Thompson.
Thank you, Madam Chair. Just a quick question for the folks from Sedgwick County. I'm looking at the nuisance codes that you have in there, and J, which is the very last, reads, any other activity or condition of like character that constitutes a threat to the health or safety of any person. I understand what you guys are trying to do. I'm just trying to figure out if we are opening the door to any property rights issues here.
Well, from somebody that owns a lot of property and lives in these areas, I'm not concerned. And I am concerned that my property can be devalued if I had a situation like this next to my property.
Well, I understand.
I worry about my property rights in other ways.
Right, I understand.
All right.
That's what, just clearing that up.
All right, thank you.
Thank you, Madam Chair.
Senator Bowers.
Yes, I'd like to make a motion to pass Senate Bill 52 out as amended, favorably for passage.
I have a motion. Do I have a second? Second by Senator Francisco. Discussion. Seeing none, all in favor say aye. Aye. Opposed? No. Motion carries. Thank you all for your time and your work on this. I'm sorry, we have one real quick deal. Senator Straub?
Thank you, Madam Chair. Sorry I didn't present this earlier. I was thinking I had Monday and then realized Transparency and Ethics meets on Monday, although it would fit there also. I have a bill presentation. It's RS 0627 concerning counties and establishing procedures for the adoption of term limits for members of the Board of County Commissioners.
Any questions? I have a motion. Do I have a second? Second by Senator Warren. Discussion? Seeing none, all in favor of introduction, say aye. Opposed, no. Motion carries. Again, senators, is this on this?
No, it's not.
I'm going to adjourn the meeting, and then you can ask that question. All right, anyway, senators, thank you for your work and time, and we are adjourned.